Right, guys, this is not going to take me very long at all. So yesterday we talked Delphi case and 17-page motion by Richard Allen's defence to try to get Judge Francis Gull to certify for an interlocutory appeal. What does that mean? It means an appeal against two of Judge Gull's orders. One about denying the defence's motion to suppress the confessions that Richard Allen made while he was psychotic, and second, the order granting Nick McClelland, the prosecutor's motion, to limit what the defense could talk about. All right, we're all there. We all remember that. Well, the 17-page motion by the defense has now been objected to by Nick McClelland. Here it is. Nick's taken a leaf out of the Judge Francis Gull school of saying very little, and the little you do say is absolute nonsense. All right, state's objection to certification of orders to allow for interlocutory appeal. Now comes the state of Indiana by prosecuting attorney, the slickness, and respectfully objects to certification of the court's orders dated 28th of August and September 4th, 2024 for interlocutory appeal. In support of the objection, I, Slick Nick McClelland, says very little. All right. But he's going to ask the court to consider the following: that on the 28th of August 2024, the court issued an order denying the defendant's motion to suppress statements made when Richard Allen was psychotic. Then on September 3rd, or was it September 4th? We don't know. The court issued an order granting the state's motion in limine in its entirety, the 12 things that Nick did not want mentioning. There's only two of them that are important, though. One of them was the entire defence. You know, the third-party culpability defence. None of that. None of that's happening at trial. And arguably, in my opinion, as important or even more important than that, is Nick wants the geofencing data, his own data, put together in his own discovery by his own law enforcement officers. The geofencing data that clearly shows that Richard Allen's phone wasn't there at the crime scene the time that Nick says the murders took place, but other phones were. Well, that all banned, all gone by Judge Gull. 3, that the defence is now asking the court to certify those orders to allow for interlocutory appeal and delay the trial setting. They didn't ask for a trial delay. I mean, arguably it will delay the trial. However, they didn't ask for a trial delay. That under Appellant Procedure Rule 14b(1), which outlines the grounds for an interlocutory appeal, it states that if the order involves a substantial question of law, the early determination of which will promote a more orderly disposition of the case, the court can certify that order for interlocutory appeal. So, if the order involves a substantial question of law, so I would imagine it would be a big question. Giving a jury 61 confessions which don't match the crime scene by a psychotic man, I would imagine there's a question. There's a question about the veracity of that evidence. And second, as the defence pointed out in all the law that they're pointed out in their 17-page motion, denying a defence, well, surely constitutionally a bit suspect. Right, but let's continue. That in both the August 28th and September 3rd orders from the court, there is no question of law to be debated. Okay, no question of law. All right, well, I can think of some questions. The law concerning the motion to suppress and the motion in limine is well established and clear. Which law? Which laws are well established and clear? Yeah, motions to suppress. Yeah, you can do that. But why Judge Francis Gull denied that in the circumstances is very questionable. And yeah, motion in limine, yeah, you can post those. But an order that grants such a motion in its entirety, I would say, is very questionable. The orders in no way involve a substantial question of law. Rather, the issues presented and decided, which are the basis of the orders, are questions of fact. Look, guys. Who determines fact? Who determines fact in a criminal case? Who determines fact? Fact. Not law, but fact. So he's saying no questions of law. Irrelevant. These are questions of fact. These are facts. Who determines facts? Answers on a postcard. I'll tell you, it's the jury. The jury. But the jury are going to get a very warped opinion of what those facts potentially are. That's what Nick wants this trial to be. Questions of fact are appropriately determined at a trial level by the presiding judge applying controlling law to the evidence presented and accepted at the hearing on both issues. No. Judges don't determine facts. They don't determine facts. Listen, they don't determine facts. They sit and preside over the law. When I was on a jury, I know it's my country, but we have the same judicial system. When I was on jury, murder trial, the judge said to us, I, the judge, is the judge of the law. You, jury members, are the judges of the facts. The facts. So again, the judge is not there to determine facts. She's there to apply the law. All right, tell me if I'm wrong. That evidence as to both issues was presented at length by the defence. That the defence was not able to meet its burden on the suppression issue or in any of the issues outlined in the motion in limine concerning third-party motive, geofencing, or any other topics outlined in the motion. What, like, don't call me names, I might cry. Don't call me names. Come on now. I've got to ask the question again. Why does Nick not want the jury to hear about the geofencing? That's the question that we should all be asking. The burdens on the defence as well established in law, both of these areas. Yeah. Okay, that the defence has not shown that the orders from August 28th or September 3rd contain a substantial question of law. See my previous comments. That an interlocutory appeal would delay the trial for a second time. Well, again, they've not asked for a trial delay, but arguably it would be the judge. It would be the judge and the prosecutor who have put this impossible quandary in front of the defence. It will be them that would be responsible for delaying the trial. That delay of a long, complex trial so close to the start date is burdensome on the state and on the family of the victims. While my heart bleeds for the family of the victims, who was it who delayed the trial that was due to start in January? Who was that? Think back and answer the question why that was. That, given the fact that the law is so well established in these areas, which areas, which law? You're meant to cite the law in support, right? So that Judge Gull can, or the Supreme Court or the Courts of Appeal or anybody, the justices of any, whatever court, can look to apply the law. What law would you like them to look at, Nick? What law do you think is relevant? We're talking about application of law. You don't just say, well established in these areas. You don't say that. You say, which law? Which law? Okay. There is a high unlikelihood unlikelihood of a different outcome at the appeals level. So he is now preempting what an appellate court might say. Therefore, the burden on the state, the families of the victims and the county of continuing a long, complex trial so close to the start date is greatly outweighed by the limiting chance of a different outcome in an interlocutory appeal. What he essentially wants, therefore, is to put the families of the victims and the county through the expense and the trauma of a practice trial, which is, if Richard Allen is convicted, is going to be appealed with potentially a lot of issues to back it up. But Nick thinks that delaying this long, complex trial is the defence's fault. That the motion to certify the orders for interlocutory appeal should be denied. That this filing should be shown as a waiver of the 15 days permitted for any response, blah, de blah, de blah. Wherefore, the state of Indiana, by prosecuting attorney, respectfully requests this court to deny the motion by the defendant to certify the orders. Of course she will. Look, if she says, no, maybe I was wrong, maybe we should send this for an interlocutory appeal, I will eat my words gladly. But I don't think she will. She'll just go, denied.